A former vice president of the ECOWAS Court, Professor Friday Nwoke, has called for the inclusion of criminal jurisdiction in the court's mandate to enable it to handle criminal cases. He threw the challenge during the ECOWAS Court's 2025-2026 legal year celebration with the theme, ECOWAS Court and International Law, Expanding Access and Navigating Contemporary Challenges in Abuja.
Access to justice is one of the fundamental human rights that the United Nations has emphasized, because you cannot establish a court without granting access to persons to be able to navigate their rights. But it appears that it's only in the area of human rights that community citizens has been given access to the court. And that is why it becomes imperative that in other areas, including especially the interpretation of the protocols, establishing the interpretation of the protocols of ECOWAS, that it appears that it is time also to give individual citizens the capacity to determine, especially where their rights are indirectly violated, to be able to approach the courts equally, since the member states who have the priority of approaching the courts in that regard has failed to do so, perhaps for one reason or the other. If you look at the supplementary protocol, for example, on the sanctions that the community can impose on defaulting states, only states are given access to the court for purposes of pursuing sanctions against member states that has violated the laws of the community. But I think that this is too restrictive, since essentially since 1979, this community has emphasized ECOWAS of citizens and not ECOWAS of states, because the major beneficiaries of the trajectory of integration are community citizens and not necessarily member states who represent them.
He stated that Article 24 of the Supplementary Protocol stipulates that the enforcement of the judgments of the ECOWAS Court is to be enforced through the civil procedure rules of the courts of the member states. Nwoke stressed that to make international law part of their domestic law, it was imperative that member states should try as much as possible to incorporate community law.
It's imperative that the states of this community, especially those that practice the dualist system, should try as much as possible to incorporate community law, because community law begins from the states, not from the top. It is because of the activities of ECOWAS citizens that community law will be in a position to develop. Therefore, it is necessary for national courts to understand that the ECOWAS Court of Justice is not a competitor. ECOWAS Court of Justice is a partner in progress. And how can we achieve that, especially, like I said, in dualist countries? By incorporation. Our national assemblies, our legislative institutions should be in a position to incorporate the principles of the court within the ambit of their legal system. For example, if you look at Article 24 of the Supplementary Protocol, that hinges on the enforcement of the judgments of this court. It talks about the ECOWAS, the judgments being enforced through the civil procedure rules of the courts of the member states. How can it be possible, let me emphasize again, in the dualist countries, where ECOWAS Court of Justice has not been recognized within the municipal law system as a court whose judgments can be enforced through the civil procedure rules? I think we think that it demands a political will on the part of member states to undertake their obligations. Because one of the basic principles of international law relating to treaties is pacta sunt servanda. Every state, every party to a treaty must take practical steps. It is a responsibility. It is not a privilege. It's a responsibility. It's an obligation for states who have acceded or signed or ratified a treaty to take steps through the principles of their municipal law to make sure that they carry out their international obligations, including ECOWAS obligations. My lords, the president of the court, and distinguished ladies and gentlemen, the political will appears to be one of the facets that is lacking in the area of the enforcement of the judgments of the court.